Our third case this morning is number 59923-6, dependency of JG.
Good morning, Your Honor, and may it please the court. My name is Colin Patrick with the Washington Appellate Project. I'm hearing on behalf of the petitioner, Ms. G. Courts should scrupulously honor due process protections for parents because the right and interest, the custody and care of their child is of paramount importance. Unfortunately, the trial court failed to adhere to these protections and give them their due reverence as it displayed an unconstitutional risk of bias towards Ms. G during the hearing and failed to hold the department to account to prove all elements of termination. For those reasons, we're asking that the court reverse the termination order for terminating Ms. G's parental rights to her son, JG. Turning to the first issue, which is the unconstitutional risk of bias. As I've already stated, parents have a fundamental liberty interest in their child, which is secured by a number of due process guarantees, including the right to an unbiased fact finder. This is kind of a squishy standard, as our courts have noted, that it is an objective test. It's not required to establish that the judge was actually biased, but rather that a person would find a objective possibility of unconstitutional bias based upon any number of factors, including of which the way in which the trial court behaves during the trial. And so with that, I'd like to turn to the record and what I've pointed out already in the briefing, where the trial court goes far beyond what is acceptable and in fact makes a number of comments towards Ms. G, as well as some factual considerations that it engages in, and some statements about not being able to move past certain things that demonstrate risk of bias.
So your client's trial counsel told the court that it had immense respect for the court and all the colloquies that were happening because they were, quote, therapeutic and helpful. Now, on appeal, suddenly those colloquies are not described as helpful, they're described as bias. I'm not sure I follow. And does it matter that you didn't object below?
It would have been helpful to object below. I think we would have been under the appearance of fairness standard, but I don't think it requires an objection. There's a number of cases, Blizzard, ANG, that discuss that this issue is reviewable under the due process clause as it is a constitutional issue, and it is manifest insofar as it's identifiable within the record as the comments. So this resolves 2.5. Now to the thrust of your question, which is what the trial counsel said, and I understand why trial counsel said that. It is a difficult situation where you are threading a difficult needle, where the court is saying things that you might not like, but you are still concerned about the outcome for your client. So you walk a fine line. That doesn't necessarily mean that the court does not establish bias here, nor does it mean that this court is precluded from applying the correct test of establishing whether or not there's an objective possibility of bias, which there is here. Not only does the trial court repeatedly interrupt Ms. G to claim that, or to say that she is making excuses, particularly when she is describing her trauma around providing urine analysis tests, where she says, the trial court says that you have an excuse for every single thing that you've done. That then almost immediately builds to where Ms. G is articulating her concerns about the foster parent's treatment of her child, of her son, and the court interrupts to unconscionably and erroneously blame her for her child's medical conditions. There's no evidence in the record that supports this, and that is, as the state recognizes, but this is uniquely problematic. The department spent a vast amount of time articulating that Ms. G should have her parental rights terminated because she is unable to care for the unique medical concerns of her son. In a world where the court is expressing an inaccurate and unconscionable belief that Ms. G is the cause of those problems, it necessarily follows that there is an objective possibility that the trial court is drawing negative inferences from how Ms. G acted and using that to claim that is biased, to use that to draw negative inferences from her. But this is uniquely bad because it happens during the presentation of Ms. G's case. This is different than laying down orders when you've heard all of the evidence. This is in the middle of her testimony, in the middle of her termination trial for her son, where the court is interrupting her, telling her she's making excuses, and telling her that there's no way I can move past this and there is no wiggle room here prior to the close of evidence. That is a level of prejudging that is unacceptable. I'd like to turn briefly to the second issue, which is the all reasonable and necessary services. I won't restate most of the law. I'll get into the facts here, which is that on page 166 of the record, social worker King states that she was aware roughly a year into the dependency, which would be about April 2022, that mental health was a parental deficiency. And she believed that rather than substance abuse affecting mental health may be causing her substance abuse problems. At that point, that is what triggers the requirement for integrated services, because as we know, based on SJ, which is cited in the briefing, that when a parent has co-occurring problems that are mutually reinforcing, the department is required to recognize that and tailor its provision of services. It didn't do that. It offered walk-in assessments for mental health treatment. It never once went to the court to add it. It never once asked for a dual diagnosis evaluation. It never once even suggested looking into this. There is multiple times where they say that the only thing that they talk about during the family team decision meetings is substance abuse. There is not the necessary focus on mental health and the way in which the department knew it impacted Miss G's ability to complete substance use treatment. And there's a failure to tailor services so as to ensure that that does not happen.
So did council request integrated mental health services from the department?
I don't know if council requested I don't believe that's in the record. That doesn't change what the department's obligations are in a world where the social worker is aware that it's a parental deficiency and is aware that it is affecting her ability to complete substance use treatment. It shouldn't be on the
Well, I guess
parent.
what I'm getting at though with that question is there's a duty at the termination trial to make your arguments to the court as far as what's missing, what makes termination inappropriate here. I mean, obviously the burden is on the department, but you've got to object to things that are missing, right? You've got to point out to the court, hey, there was no integrated services provided here. Was that argument made to the trial court?
I see that I'm out of time. May I respond to your question?
Of course.
I understand that it is not articulated exactly as integrated services, but it is articulated as the way there are articulations throughout about the ways in which mental health was left off. The trial counsel discusses how mental health was impacting her ability to complete other court services. So while it may not have said the exact words integrated services, it is asking the court to hold the department to its burden to tailor services necessary for Miss G. It did not do that. It ought not have to make these magic words of integrated services when it is identifying the exact problem, which is that they are failing to provide mental health services, and that has affected her ability to complete court-ordered services like substance use evaluations. That is describing integrated services as a concept. It should not have to be named in order for that issue to be reviewable.
All right. Thank you, counsel.
Thank you.
And counsel for respondent, you can proceed when you're ready. Counsel, I can't hear you. Sorry, you're muted still.
Sorry. May it please the court. My name is Jeffrey Weiser. I am here representing the Department of Children, Youth, and Families. Today, the department requests that the court affirm the order terminating AG's right to JG for 4 key reasons. First, AG did receive adequate notice of the parental deficiencies relied on by the department at trial, consistent with the requirements of due process. Second, AG's due process right to an impartial finder of fact was preserved and she received a fair trial. Third, the department proved it understandably offered AG all court-ordered necessary services capable of correcting her parental deficiencies throughout the 3 years of the dependency. And fourth, the substantial evidence supports the trial court's finding that AG's parental deficiencies would not be remedied in the near future. I'm going to try to focus on the 2 key areas that appellant's counsel brought up, but please let me know if you have questions on the other 2 subjects. Turning first to the judicial bias. As the court noticed, for the first time appeal, AG raises a due process challenge claiming judicial bias. She argues the number of the judges questioning deprived AG of the due process right to a fair trial. This was not something properly preserved below. In fact, as the court mentioned, it was, the arguments that were made, the discussions made by the court were acknowledged by trial counsel at the time as being helpful and therapeutic. In order to raise this, the council must show the error is manifest and the error is truly of constitutional dimension. This requires a showing of actual prejudice and demands the error be obvious on the record.
So I guess the most problematic part of the record that goes to that standard, though, is this assertion by the judge that the medical problems of the child were caused by the mother's drug use. That there was no medical evidence to support that at the time that the judge made that statement. Isn't that right?
You are correct. There was no evidence presented at trial, nor was it something relied on the department, nor was it something that was repeated again in the findings of the court. It wasn't something tied to the actual finding of unfitness, which was the substance abuse by the mother as a whole, not as a tied to the care of the child. This was simply a mistake of fact.
Well, does it have to be relied upon in order for it to demonstrate the level of bias needed for a remand?
I don't think it should be demonstrated by the appellant that there was some harm to it. But again, this was not tied to any of the findings. It was just a mistake of fact that was based on the initial dependency petition and with some of the grounds of removal. It was not part of the concerns raised throughout the dependency, nor was it part of the findings. I think when we're talking about the concerns about attending to the child's medical needs, that was based on the fact that the mother had failed to attend any of the medical appointments throughout the dependency and not really tied to the any concern that she actually caused the underlying injury.
No, so I guess what I'm proposing is it should be that if a judge shows bias during the questioning of a witness, it doesn't really matter what their factual findings are. If that questioning shows bias, actual bias, then there should be a remand because we can't have a biased fact finder. Isn't that right? Or do the actual fact findings themselves have to be shown to be influenced by that bias?
No, I think if you remove the finding of anything with the craniocytosis, you get the same outcome. I think looking at the arguments and concern of bias, we're talking about a very small part of the record, about 11 pages out of a 300-page record. The timing, I think, is also key that we're looking at. This wasn't something that came up in the middle of the termination trial, nor at the middle of the mother's testimony. This came up.
Well, saying that we get the same outcome, it starts to sound like you're arguing for harmless error. What I'm trying to get at is, if we've got, just hypothetically, set this record aside, if we've got a judge who's during witness questioning saying things that demonstrate that they're making leaps that they shouldn't be making and they're demonstrating an actual bias, does it matter that that bias doesn't show up later in the fact findings?
I don't believe that there was anything more than just a mistake of fact from one of the comments made in the petition that was filed by the department early on in the dependency.
That's not really answering my question. So let's focus on my hypothetical. If a judge demonstrates actual bias during the questioning of a witness, is that worthy of a remand, even though their bias is not demonstrated in their fact findings or ultimate conclusion of law?
If there was a finding of actual bias, then yes, a remand would be proper. To a reverse remand would be proper to a different judicial officer.
Okay, and if that's the case, then doesn't the questioning here where they make an assumption about the cause for the child's medical issues and blaming it on the mother, isn't that a sufficient enough bias to require a remand?
In this case, I think it is a minor issue that came up. It was a mistake of fact stated by the judge that wasn't related to any bias. It was more of a colloquy, I think, as counsel at the time mentioned, was therapeutic, trying to point out some of the concerns that the mother may have had that may have led her to the situation.
If that was the case, well, I guess what I'm trying to get at is, doesn't the fact that the judge is constantly questioning the mother's explanations support this argument that this wasn't an isolated mistake of fact and in fact demonstrated some kind of bias towards the mother?
Yeah, I think looking at the record as a whole, like I said, this came at the very end of the testimony. I think there are other statements made by the judge during that same time that indicated there was a little bit of bias more towards the department. If you look at page 256, she stated that she's the hardest person on the department, that she hardly ever finds for them if possible. She mentioned that even after the comments with the mother, that she still wanted to go to closing, but that she hadn't decided at the time yet. And then even when there was redirect to the mother later on, you saw the judge sort of flip over into questions that were supportive of the mother's arguments or diminishing her concerns when she had referred to on page 271, 272, people sleep, mothers sleep in the hospital rooms after they've given birth. We are exhausted. You had a C-section. Yeah, I understand. She was still, very much trying to answer the questions that she had for the mother at that time.
Okay, thank you. And I don't want to take up your entire amount of time. There are questions about the services issue as well, if you wanted to address that.
Yes, this is something else that was raised by AG for the first time on appeal on integrated mental health services. There's a concern that these services were never offered. These were services that were never mentioned within the throughout the termination trial. And I think the key thing to mention is that during the dependency, the mother did have a number of psychological evaluations, that she went to mental health evaluations and substance abuse evaluations. No professionals in the underlying record indicated that integrated mental health services or dual diagnosis or any other co-occurring therapy was indicated at the time. This was something raised for the first time, but that's not supported by any evidence in the record.
So what is the trigger for requiring integrated services? It seems like just generally from reviewing these cases, there's almost always integrated services when you talk about people who have this level of drug use. Is the trigger that you need a diagnosis or some kind of screening that recommends integrated services? Like when is the department required to provide integrated services versus just drug use services?
I think it's twofold as you go through. When you talk about the integrated services, I think part of that is going to be based on both the evaluation done by the professionals. The department, their social service specialists, their focus is reunifying families, working together and providing the needed services. They are not substance abuse counselors. They are not mental health professionals. They must rely on those mental health professionals and substance abuse professionals to tell the department what services are recommended. Even if they were in this case, we did have the problem where the mother had revoked a release of information that would have allowed the department to know if those services were recommended. Regardless, the department continued to offer them throughout the dependency. It was over 2 years from the first time the initial mental health evaluation was done to the final evaluation done, even just months before the termination trial. They continued to offer the services to AG to be able to remedy both the substance abuse and mental health issues. If it had been recommended by a professional, then the department would have helped her obtain those services.
So I'm just not clear on your answer to my question. Is your answer that the trigger is there has to be an evaluation recommending that to the department?
I think as you go through the record, I think it is exactly, you do the mental health evaluations and you do the substance abuse evaluations, which come up with the professional recommendations, which would have included, if they'd been indicated, the integrated mental health services or co-occurring therapy, at which time the department would have triggered the requirement to move forward with the referrals and the support for that.
Okay, thank you, counsel.
As I'm running out of time, just to conclude, the department asked this court to affirm the order on termination. The mother received a trial from an impartial fact finder and had notice of all the grounds of termination. The trial court's finding that all services necessary to resolve parental deficiencies and there is little likelihood the deficiencies could be resolved in the near future, are both well supported by substantial evidence. Thank you.
Thank you, counsel. And counsel for petitioner, I'm going to give you an extra minute because I bothered you at the end of your time there and didn't let you reserve all of your time. So you can have almost 3 minutes there for rebuttal and you can proceed when you're ready.
Thank you, Your Honor. I'll start with talking about whether or not this is structural error. It absolutely is structural error. It doesn't matter if it was relied on by the court. Williams v. Pennsylvania, which I don't cite in the brief, but is 579 U.S. 1, cites Puckett v. United States, which is 556 U.S. 129. Both of them say that due process challenges regarding an unbiased fact finder are not amenable to harmless error review, and it is a structural error. It's very simple. The argument that the department is making about that it's just a factual misstatement is problematic because how does she reach that assumption in a world where there is no evidence to support it? And we can look to the questioning prior to that, where she is calling her trauma excuses and constantly interrupting her to tell her that this does not matter or it is non-responsive. The fact that the state or the department points to other questions where the department or the court is not doing that does not mean that it is not biased. The fact that it operates 70% of the time not in a biased manner doesn't mean that the other 30% of the time is uniquely problematic and demonstrates actual bias.
So did counsel for your client at the trial attempt to correct the judge as to that misunderstanding?
I don't believe so. That again, I don't think that changes the underlying problem though, because if they would have corrected it, it wouldn't have changed that the court had already made that assumption, because the trial court had no duty to correct something that would not have been known to be proven. So even if it had corrected the court, that assumption still underpins why the bias underpinning that assumption still exists. It doesn't just go away. It is the reason as to why that assumption was made. Turning to the second issue, I want to talk about when integrated services are required, and that is when there is reason to believe, the department has a reason to believe that this is necessary to solve it. And again, that is really unchallenged, that on what's on page 166. And the idea that the department needs a diagnosis of co-occurring obfuscates the point, which is that the department never referred anyone to that. Dual diagnosis are a
I'm
different...
sorry, we're going to run out of time. Are you relying on a statute or a case for the proposition that the department has to act when they have a reason to believe it's necessary? Like what authority are we using to?
I think
construct
SJ is
that?
probably my best authority. I don't think SJ says that exactly, but that's kind of the underlying principle, right? Is that, and that's supported when they talk about the legislative intent, that when the department is aware of an issue, it needs to take steps to address that. It cannot simply not do anything, which is what it did here in terms of just making more walking evaluations. There is no indication that the department ever asked for a dual diagnosis evaluation. So the idea that they needed to wait on that diagnosis when there was never any indication that they asked whether or not she had that diagnosis illustrates the problem and illustrates the unique concerns here, which is that the social worker knew it was affecting, her mental health was affecting her ability to complete court-ordered services, and it did not go to the court. It did not ask for a dual diagnosis observation, and it did not bring this up in the family decision meetings. The department cannot sit on its hands when it knows this. It has to act. Because of that, I'm asking for the court to reverse the termination order to Miss G's son, JG. Thank you.
All right, thank you, counsel. Thank you to both parties. The matter will be taken under advisement, and this court will issue a ruling as soon as able. Thank you.
Thank you.